After an accident, minutes matter. Your words and actions matter even more. You need help, and you need it now. This is David versus Goliath, brought to you by Dolman Law Group Accident Injury Lawyers, a boutique firm with a reputation for going head-to-head with the insurance company giants and putting people over profits.
Welcome to another episode of the David vs. Goliath podcast. My partner in crime, Stan Geip, is not here. He's away on spring break, so you just have me, Matt Dolman, the host, and I have the esteemed guest, Brett Turnbull out of Birmingham, Alabama, with the firm Turnbull, Holcomb, LeMoine. I work with Brett a lot, so, for a little bit of candor here, Brett's one of the top trial attorneys in the country. My firm co-counsels a number of cases in several different spaces: catastrophic litigation, AFFF firefighting foam, which we're going to talk about later on in today's podcast, but what we're really here to talk about is the NEC infant baby formula litigation. There was a verdict that came out last week, Brett, at St. Clair County in Illinois for $60 million. Let's talk about NEC. What does the future, what does the landscape of NEC look like right now? I know there's a state court play, and there's active state court dockets in Marion County, St. Clair County, Cook County in Illinois. There's one in St. Louis, I believe, and I could be wrong. I think there's one in Philadelphia too, and possibly in California. And then there's obviously the MDL that's going on. So let's talk about it all.
Yeah, thanks, Matt. I appreciate it. Of course. The state of the NEC litigation is in high gear. Really, the cases can be filed in any state court with a little bit of strategy in terms of having some local defendants that could potentially be individually brought in as well. And of course, the MDL is available and is pending too. So even though most of the cases that you see the lawyers have filed are in, St. Louis, Edwardsville, and Chicago, Cook County, those type of venues, that's really by strategy. Really, it could be filed anywhere most of the time because you can have the sales reps added in as an individual defendant and make a state court play. And again, MDL on the federal side. So it's available from a jurisdictional perspective. It's been pretty wide and diverse. And so, that just to kind of start off, that's really an interesting point about NEC.
What are the dangers of cow-based milk formula? What's the dangers to preemies? We talk about premature infants, and then the disease of, and I hope I'm saying this correctly, is necroenterocolitis, which could be deadly in especially a developing premature infant who does not have a developed gastrointestinal tract.
Yeah, so the bovine milk, or the things that you would normally see that are put into the formulas, are dangerous for these babies because, like you said, they don't have, their digestive system isn't developed enough to really be able to withstand the irritants, if you will, from that. And so what happens is the formula, if a mother is either incapable of breastfeeding because her milk hasn't come in because the baby is so premature that it hasn't, physically the milk isn't even available. Or unfortunately, if the mother has had some things that would make her not a candidate to supply breast milk to the baby, whether it's drugs and alcohol, the different things that you see sometimes with premature babies, you have to have, the formula is dangerous. And it's dangerous because there is a significant percentage, and we're learning that percentage is higher and higher than we ever thought, of babies that when they get the formula, they're going to suffer from NEC. And NEC is a 50-50 death mortality rate. It causes the internal parts of the small and large intestine it irritates it in a way that it inflames it. It causes it to slough off, and it dies. And so you'll have entire parts of the baby's intestinal system that could die. You'll have bacterial infections. You'll have terrible things. Like I said, it's a 50-50 mortality rate at that point. The formula is, we now have data from, I think it's now out in the public domain, from the documents in the cases that show that there are actually 20% of babies who suffer from NEC as a result of, the formulas that we're talking about here.
I remember early in the litigation, and I know we discussed the other day when we were talking about the case on the phone, that, a worry originally or initially in the litigation was, what is the liability of the medical facility, the hospital, or the NIC unit where they're treating the premature infant? And then how do we put it on or liability on the manufacturer as opposed to the physicians? And when were they aware of the science?
Yeah, the science they've been aware of the science for 20 years. I mean, that's not even really up for debate at this point. They will admit that there is, quote, an increased risk. They will not quite admit the relative risk and how bad it is, but they do say there's an increased risk, and I think they've admitted that for a long time. Yeah, one of their big defenses is, well, we told all the doctors and we told the hospitals, and everybody should be passing that along to the patient and accepting the risk associated with NEC for these premature babies with the formula. So that was really what they were kind of using, almost sort of like a quasi-learned intermediary type of defense, where, let's face it, a lot of the doctors and hospitals the buying departments of the hospitals were concerned about various things. You can imagine that they were kind of wondering what was going to happen with them. And so that was early on, that was a huge, and it's still an issue. It's still something that that's having to be dealt with on a case-by-case basis. But what we found is that ultimately, at least from a legal perspective in most jurisdictions, we're very optimistic that it will be really more a function of what was the consumer told and what does the consumer say, i.e. the mom. That would be our position. They say the consumer is the medical providers. We say it's the mom in making those type of decisions. And the moms, obviously, I can't imagine, 99.9% of them will testify that this was never brought up. It was not a risk or an issue that was discussed with them.
And if it was discussed, I'm just getting granular here, are there other alternatives besides cow-based milk formula?
Yeah, well, there should be. That's the big beef, is that there's the big problem we have with it is that there's definitely donor milk available. If there was more demand for it, it would be more organized. It would be distributed more plentifully, if you will. There's plenty of it that could be had, and because the buyers in these hospitals, and because it's sort of like a hush-hush type of situation across the board, manufacturers of the formula can't make money off the donor milk. That's our position, is that's the motivation, is that that takes out a percentage of their ability to sell their formula. And frankly, there's probably some truth to the fact that I hate to say it, but it may be a little laziness on the part of the medical providers, that they say, well, these babies are premature. It just goes with the territory. And, dealing with a totally separate channel for donor milk is a headache. So that's all. And that's just sort of that's a candid point that is perhaps part of the problem. But, part of it, that's what we do, Matt. You and I and all of our colleagues, is to change things that are wrong and to change things and make them better, make them safer. And that's surely what we hope to do here.
So the big defendants are Infam and Similac. Are they acting in concert with one another? Is it the same approach that both defendants are taking? Are they looking at this differently? I know the trial that occurred in St. Clair County, it was a consortium of law firms involved. I think the main trial attorney was Sean Grimsley of Denver. Was that case was against Similac? So is Infam also involved, in how many cases, and who's bigger in terms of who has more exposure? And do they both have the market cap? Do they have the resources to pay these judgments?
Well, to answer your question first, yes, there are two primary defendants in Mead and Abbott Industries, and that's the Infam and the Similac. That's where you kind of see, and from a market share perspective, I haven't done tremendous amount of research on this, but it's pretty equal. I think that their liabilities are going to be fairly equal, and I think that in terms of their strategy so far, there are some details that are a little different, but as a general concept, it's very, very similar. And, last question in terms of market cap, it's always tough to say these days with the way the world's been turning in the mass tort world. But I will tell you that from a numbers perspective, there are a lot of babies out there who have been affected, a lot of families that have been affected, but the number of cases so far seems to be the valid, and cases that are being fought hard seem to be a manageable number.
Yeah, I just guess taking a lay of the land, you look at the landscape right now in mass torts. Even Bayer is threatening to file for bankruptcy again and try the Texas two-step that we saw Johnson & Johnson try, and then eventually we saw 3M unsuccessfully try that in the Seventh Circuit. And I don't know if Bayer is going to do that on behalf of Monsanto, the parent company, based on the string of Roundup verdicts that have been occurring. But I think that's going to become a trend that we're going to see over the next several years, is more and more of these attempts until the Supreme Court of the United States speaks out on this issue. Eventually, one of these cases will get kicked up there, and they'll probably, hopefully give us some guidance, because what we're seeing is these big manufacturers, these big publicly traded companies, they dump a lot of debt and very few assets into a sub-company, which is clearly a thinly veiled concept to get around paying judgments and to declare that they're bankrupt and they're not solvent enough to pay out judgments. It's just something that I've been seeing, and that's why I wanted you to comment on that. But a segue to this is, how do you choose, you're one of the top trial lawyers in the country, and I know you're involved in a number of mass tort projects. How does a group of lawyers, and you're working with a group of law firms that are working on these projects, how do you determine whether you make a state court play or you stay in the MDL? What's the benefit to one versus the other, and how does that work?
Well, the first thing that I would say to that is in some scenarios, the MDL is the only option. In some litigations, that's just the way it is. I mean, CPAP with Phillips is an example. Frankly, AFFF, the firefighter foam litigation, I'm unaware of any real state play that exists. So sometimes that's just the way it is. In terms of these opportunities where there's a little bit of a choice, obviously the venue is the first thing to consider. I practice in Alabama and Georgia primarily on the single event side. And so as an example, one county over from one county over is a totally different animal.
Same here in Florida.
Yeah. Judges, juries, the whole nine, right? So ultimately it's really just a venue question. And then, there are, like you said at the outset, you're absolutely right. There are state court dockets that get created, especially in places like California, Los Angeles, places like that, where you're going to have a lot of plaintiffs that are going to file in, and they sort of organize the best they can, kind of almost like a mini MDL in state court. And so sometimes you find continuity in the leadership of the group, lawyer-wise. Sometimes it's a function of certain cases that are stronger, maybe, but some that qualify, but maybe aren't quite as strong, that are better put with the thundering herd, if you will, on the MDL side. So some of it has to do with the case, some of it has to do with the venue, and it's a little bit of a detailed analysis. And unfortunately, what we're seeing in some litigations is that the defendant will get traction in one venue sometimes, and there's a whole bunch of cases plugged into there, and that's where they want to push the cases, right? And so It's a little bit of a risk to have pockets of cases all over the place, because you can find a scenario kind of like what's happened with the county, St. Louis County in Roundup, which has been the defendant pushes those cases based on where they are and who's leading the charge on the judicial side of that. Not all I'm willing to say on that. But they find pockets of people that they think that they have some favor with, and they shove it on their end. So a little bit of risk, but could be great reward. And sometimes it's nice also because the defendant has a better ability to handle sometimes docket resolution in a state court scenario than they might with the entirety, the big barge rolling down the river.
So to give those who are listening kind of an overview or lay of the land, so to speak, I've been using that term a lot in this one. California, Missouri, Illinois, Pennsylvania, Delaware, New Jersey also have almost like mini MDLs within their state. They have coordinated proceedings in state court where the cases all get consolidated before one judge or one venue within that state. In California, it's known as the JCCP, the Joint Coordinated Civil Proceedings. What is the play here that you're having in NEC? Are you staying strictly in Illinois State Court? Are you going into Missouri? You mentioned St. Louis. I know there's a trial coming up. One of your partners is going to be trying. What does that look like? Where are you aiming at?
Well,
as much as you can disclose, obviously.
Yeah, I mean, as much as possible, in Illinois and St. Louis would probably be the preference, but it's not always feasible. The Chicago State cases that got filed in have some procedural issues that are before the court that are taking some time to determine whether they're going to stay there or not. So that's been a little bit of it slowed things down a touch. Doesn't mean it's going to be bad. It's just slowed things down. There are some plaintiffs who unfortunately won't even have really the ability to file in either of those places in state court. Some of it has to do with where the plaintiffs are. But yeah, I mean, preferably those are the places, East St. Louis, St. Clair, and St. Louis County would be the ideal scenario, Chicago, Cook County. But that's just, from my perspective. And I would need to do a little more research. I haven't, the Philly crew, I'm not as familiar with what they're up, what they're doing. So, the next trial coming up is Tor Herman's firm is going to lead charge. Jake Plattenberger, great friend, the city of St. Louis, and looking forward to it in July. And I know he and his crew and hopefully help out here or there. We're definitely all looking forward to seeing what happens with that and have a lot of confidence in them.
Great firm. I mean, I know Tori's a friend of both of ours, and Jake's a great lawyer. What does the future of this litigation look like? Are you following much of what's going on in the MDL? Because I know you purposely stayed out of the MDL on this one. Does it look like because it's unusual that a state court trial happens before the MDL trial, and that's usually why you have in every mass tort you have the plaintiff steering committee, and there's always liaison counsel, and liaison counsel's job usually is to regulate and prevent state court plaintiffs from getting ahead of the actual MDL and to coordinate the discovery so that they can get paid their common benefit fee, which is part of what I hate. If there's one thing I do dislike about mass torts, it's a lot of the politics and the plaintiff steering committee and the MDLs. And we all know this. And the same usual players, and we're not going to label who they are. and I'm going to be very careful of what and not be cavalier on this podcast. But what does that look like?
Well, I do think the MDL is run by great firms in this litigation.
Yes.
But I think the reason that the state court cases there have been a couple here who look like they're going to get out in front is partly because they were filed much earlier than the MDL was created. The interesting thing about it was for one reason or another, the MDL took a little longer to take because there were state court cases that were able to be filed earlier. Number two, I think it would be impossible to disagree with this statement, and that statement is that when you are in certain venues, perhaps even a state court opportunity to get out in front and make a point to that the strength of the cases is justified. And I do understand what you're saying about potentially some of the politics and who everybody wants to go first. Everybody wants the ball, to take the last shot. I totally understand that. But I think in this scenario, the venues were good enough. The lawyers were out in front of it. And I think it was just the right thing to do.
So juxtapose that with like California, for instance, where the Uber rideshare litigation started. And actually the Northern District of California is where the MDL is now. But the cases that were in the JCCP, they were all forced into and transferred into the MDL. So those cases that are out front and center, because that JCP was created 2 years before the MDL, not a single case went to verdict, and it was stalled out as a result. So you see that in some MDLs, not in others, and it's just interesting to watch how that interplay between the state court proceedings that are running almost on a parallel track to the cases within the MDL. What are we looking at in terms of the future of this litigation? Is it going to be a number of state court trials and bellwethers within the MDL before the defendants are brought to their knees? Do we have to see a lot more trials just to see what juries are going to do with the science? What does it look like? Does it look positive? What's the future of this mass tort look like?
Well, it's obviously, and by early, it's early in the sense of we've had one trial, and it obviously was a resounding plaintiff's victory, and congratulations and kudos to the members of that team and those lawyers and that client. Most certainly, it is very early. It's hard to say. I will tell you that one of the things that we all, you and I know we've talked about this before just recently, is how hard is it for them to control the downside and sort of get things bottled up, right? That's their way in every litigation to make a run at things. And one of the challenges with this one that may or may not make it last longer than you would expect or hope is that they're still selling the same formulas, and there's not really a clear alternative plan that's been built out at this point. There's going to be some lag in there where they're able to try to get an opportunity to have some closure. And that's why there are still cases to be had, because there are still babies being given this formula, premature babies being given this formula who are suffering from NEC today. And so there's always, there are more and more people that are being affected.
What are the criteria if someone wanted to hire Turnbull, Holcomb, LeMoine to represent them in the NEC litigation? And I know you and several firms are working almost like in a consortium. What are the criteria you're looking at, if you're able to disclose that?
There's a pretty big variance. We really do stick to the formula and not the fortifier. The fortifier is which all the babies end up on fortifier after the formula anyway. But we do verify that that there was formula rather than just the fortifier. That's a first of all. We've gotten to where injuries that occur need to have occurred after 2007, 2008 timeline. And because, as you know, they're all babies, so most of the time their statute of limitations will not run in most states until they reach the age of majority, if they're obviously still with us, right? So there was a lot more older cases taken, but at this point we figured out that it's probably best that it be 2007 forward, and then obviously diagnosis of NEC, and then have to evaluate the injuries that came from that. And then look, there are some premorbidities from the mother's perspective, some of the pregnancy premorbidity analysis or the pregnancy analysis of how things were going. And there are other factors, but it's very case by case, and that's okay. How likely was it that the baby was going to be this premature and still end up with CP, regardless of whether the NEC, was the cause? And those type of analyses, which are very intricate. But I would say 2007 forward on injury, and it must be formula instead of fortifier.
Understood. Has Dobert occurred yet in the MDL?
No.
Is that coming up anytime soon, or is that scheduled, or is there
I'm not even as up to speed on the details of the MDL just because I don't have too much going on, and it probably should check into that a little bit now that you said it. But I think it's pretty early still. So I don't think
MDLs. I know they move at a snail's pace. The only exception to that was which I had heavy exposure in, was Tylenol autism, which within 1 year, literally, it started in October of 2022. By December 2023, so 14 months later, were in Dobert, which was shocking. That was a breakneck pace. No one expected it, and it got blown out. But that, it happens in some mass torts. Let's segue a little bit to AFFF firefighting foam. You've been in that since the very beginning. I mean, with full transparency, you have a lot of my cases. Yeah. I sent them over and gave, I trusted Brett Turnbull to shepherd my cases to resolution, being one of the best lawyers in the country. And you've been involved in AFFF for years now. What does that look like? I know there's been some orders recently came out from Judge Gerges, and I think it's the United States District Court for the District of South Carolina. Are they narrowing the science now? What does it look like in the individual firefighters? Because I know that the municipality cases are pretty much done. Those are settled out in blocks. But the individual firefighters still remain.
Yeah, it's a unique MDL in the sense that there are municipal plaintiffs, and there are obviously the firefighter and military members, first responder plaintiffs, and it's all kind of balled into one MDL before the same judge, which is, I would say, is a little bit unusual. But you're right. I mean, they're kind of.
We only saw that before in opioids. That's, I think, the only other time we've ever seen that.
Yeah, I mean, look, it's been fine. I mean, it's been well managed, and hats off to the leadership group on both, on the plaintiff side, and the judge and their team has done a great job with keeping it moving. It would be helpful. Maybe we get some dates for some bellwether trials, which I know is hopefully pretty imminent to happen. Yeah, some of the diseases have been narrowed. The hallmark diseases in the real Super Bowl scenario, which is terrible for the people, but I mean, in terms of the science, in terms of epidemiology, is really, the kidney, bladder, prostate, testicular. But then there are several other diseases that are still very much in play beyond that. But yeah, it's narrowed some in terms of the diseases, and some of that hopefully will be a sign that they're beginning to kind of pare down to what could be tried and what can be won.
I know this is an MDL where science really has never been in question. Exposure to X causes Y. We know that with AFFF. Has there been Dobert hearings though yet?
No, there haven't been Dobert hearings. And Matt, I'll tell you, the science is strong, the epi is strong on certain diseases. I don't want to say too much, but about the ones that are maybe not quite as strong. But there's still going to be a little bit of a fight on the science in terms of some of the diseases that have been claimed. It's just true. I mean, like anything else. But yes, you're correct. The science as a whole, in terms of the dosage, the strength of the exposure based off of the type of it's pulmonary, it's contact, it's the whole. I mean, you're obviously getting just bathing in this stuff. And it's just loaded down with PFAS. So it is the exposure side. You can these people are well documented to where they worked, whether they would have been in a position where they would have handled these type of materials. I mean, really, the way I see it, most of the only defense for the right diseases is just going to be that they could have gotten it from something else, which is not a great defense. So I mean, and let's face it, there are people that were put in this position without knowing that this was something that they were going to be dealing with, who were doing things that are brave and courageous and admirable in the first place, and then this is kind of what they end up with. It's a strong case for sure.
Yeah, the optics are 100% very strong. It's mostly military firefighters.
That's right.
Very few private firefighters I've seen in this MDL. Now,
yeah, I mean there are
who are still first responders and are still doing, incredibly brave work, and we thank these individuals. The last thing they deserve is this.
That's correct. It's a little bit, it's used differently in the military versus our everyday heroes, if you will, with the firefighters that work all across the U.S. It's a little different in terms of how it's used and how often. And so I think that's been a big part of why you see the distinction.
You were the very individual who told me to get into AFFF firefighting foam in terms of looking for these cases. And honestly, from having, the most astute mass tort lawyer in the country, but I do have enough knowledge to say I believe this is probably the safest mass tort there's been in quite some time, being just the optics of the case, jurisdiction, the leadership that's involved, and the science is just very strong. I'm not asking you to necessarily be a prognosticator, but if you could be for a moment, do you expect this to resolve this year? Do you ever anticipate there being an individual bellwether case, or do you think this is just going to get knocked out, being that the main four defendants are, I guess, DuPont, Chevron, 3M, ChemGuard? Who are all Fortune 100 companies. And then there's a bunch of smaller, I wouldn't call them little, but smaller defendants like Buckeye Fire Equipment. We can go through the whole list. But with the big four, do you expect them to come to the table over the next year?
It's hard to say whether. So one thing about this MDL, these cases that is a positive in my opinion, is that there are more defendants than usual, which kind of helps with the issues we were discussing earlier in terms of how much stress is put on a company to be able to make a resolution. So the number of defendants is a positive. There's a real chance that there will be partial settlements with defendants and not all. That is a very real potential. Don't have my crystal ball out. In terms of timing, it's always tough to say. I would venture to say that there's a real chance that there will be some defendants that are probably going to resolve sooner than others. And so to answer your question on the big four, it's hard to say specifically, but there are a number of defendants even behind those four who are very substantial companies. Are not as big as those four. All I will say without saying too much is that there's a real chance that there's going to be some resolutions and potentially a bellwether against those who remain. That type of scenario is very real.
Fair enough. So if we have individuals out there that want to contact you, want to contact your firm, how do they do that?
Turnbull, Holcomb, and LeMoine, and we're in Birmingham, Atlanta, and Houston in terms of our offices, but we work all over the country, have cases filed everywhere. Next trial is in Chicago, so
what kind of trial is that?
April. It's actually a medical malpractice case. And
okay.
So that's on deck, and we do pretty much everything personal injury, I would say, aside from workers' comp. But everything else, product liability, medical malpractice, nursing home, obviously trucking, general litigation that way, negligent security in some jurisdictions. And you can find us at turnbullfirm.com and turnbullawfirm.com, and that's where we are. 205-831-5040 is also a place to get us.
So I can personally attest to the fact that I could choose who I want to work with, when I want to work with them, and where I want to work with them. And I've entrusted Brett with my biggest cases in Georgia. We don't get a lot in Alabama, but if we do, we send it to Brett. And just cases around the country, oftentimes Brett's like a mercenary. So he comes in, he'll pro hoc into a state and handle a case. I mean, he can handle cases anywhere, but he's licensed or has lawyers at his firm that are licensed in Alabama, Georgia. You have anybody in Florida yet?
Yeah, got a couple of Florida lawyers. Yeah.
Damn, you stay out of my backyard. Nevada. I mean, you have anybody in California yet?
Oh yeah.
Yeah, so you guys are all over the place.
Yeah, no, it's the ideal is we like to try to go where we can help folks the most, and try not to let geography be a limitation on that. Thank you for the kind words, Matt. The feeling is mutual.
Love you, brother. Appreciate you coming on the podcast today. I really appreciate blessing us with your time, because I know you're very busy and you have a lot of projects going on.
Well, I can't thank you enough, and always, man. Anytime for you. Anything in the world.
Well, thank you. That wraps up another episode of the David vs. Goliath podcast. I'm Matt Dolman. The esteemed Brett Turnbull joined me today. So, again, he provides information if you have a case involving AFFF firefighting foam, if you were exposed to that. And it's very unfortunate, but if you had a premature child and they were diagnosed with NEC after exposure to cow-based milk formula, Turnbull, Holcomb, LeMoine, that's probably my go-to firm in the country for mass torts. I didn't get choked up there emotionally there. I just thought I was losing my voice. That's the problem with allergies and pollen season.
Allergies.
This wraps up another episode, and thank you very much, Brett.
This episode of David vs. Goliath is over, but your journey is just getting started. To share your story with us, visit dolmanlaw.com. That's DOLMAN law.com, or call 866-965-6242. The insights and views presented in David vs. Goliath are for general information purposes only and should not be taken as legal advice for any individual case or situation. The information presented is not a substitute for consulting with an attorney, nor does tuning into this podcast constitute an attorney-client relationship of any kind. Any case result information provided on any portion of this podcast should not be understood as a promise of any particular result in a future case. Dolman Law Group. Big firm results, small firm personal attention.